Well, good morning, everyone who's in attendance so far, and welcome to today's webinar on how can I settle my case at a case conference. And we are so glad that you could join us today. Today's session is being led by Steve Benmor, one of Ontario's most respected family law professionals. And Steve is the founder of Benmor Family Law Group and has spent more than 30 years helping individuals and families navigate separation and divorce, particularly in complex financial and high conflict matters. He is one of Toronto's certified specialists in family law, a fellow of the International Academy of Family Lawyers, and one of the few professionals in Canada licensed, certified, and accredited in all out-of-court divorce resolution options, including mediation, arbitration, and parenting coordination. And in addition to his legal practice, Steve is also the president of the Divorce Coaches Association of Ontario, DCAO, who is hosting this today, where he is a strong advocate for collaborative, client-focused approaches to family dispute resolution and increasing public awareness around supportive and healthier pathways through separation and divorce. So we're incredibly fortunate to have Steve with us today to share his insight and practical strategies on how parties can work towards meaningful resolution at a case conference. And I would also like to introduce Thea Moreau. She is a DCA certified divorce coach in ADR and the founder of the Divorce Concierge, as well as my fellow co-chair on the Public Awareness Committee with DCAO. So Thea will be leading the discussion and questions with Steve today. And for those of you who I haven't met yet, my name is Leona Harvie. I am a DCA certified divorce coach in ADR, accredited divorce coach and board member with DCAO, and founder of Let's Talk Divorce Canada. So I will be monitoring the chat throughout the webinar today. So I encourage anyone attending to post your questions in the chat as we go. And I just want to remind everybody that there are no silly questions when it comes to navigating separation or divorce, especially if your matter is before the court. And the chances are, if you have a question or if you're wondering something, others on the call probably are too. So we'll try to get the questions as we go, and we'll be mindful to leave maybe 5 or 10 minutes at the end to answer any remaining questions. So with that being said, I will turn it over to Steve and Thea.
Thank you, Leona, for those wonderful introductions. Just as a point of mention for our participants today, we will be recording the session. We will make sure that your faces and names are not on screen and in the recording, and we will be emailing this out to you after. So if you don't catch something as we're going along, don't worry, you can go back and watch it after, okay? So Steve, before we get into the meat of today's conversation, how about case conferences? Can you explain for us the difference between a conference, a motion, and a trial?
It is very confusing. And first of all, I'm so glad to be here. And Leona and Thea, thank you so much for joining me in this plight of educating Ontario lawyers, divorce coaches, and self-represented litigants in these complicated and very murky waters. So as for your question, Thea, the reality is these are difficult words. They're difficult words because they're thrown around in the courthouse, they're thrown around in documents, and it's not always clear. What does this all mean? So let me just take you back in time a little bit. When I was a young lawyer and a couple were splitting up, it was not uncommon for the day after they split up for one of them or both of them to hire a lawyer, and the lawyer's first step would likely be to go down in Toronto to 145 Queen Street West. By the way, today, that's the Four Seasons Center for the Performing Arts. But there once was a time when that was the first place a divorcing couple went to. And at that point, what would happen is they would argue a motion. And that motion would be asking a judge or a master, because they had these things called masters back then, for a order that the children live with one parent and that one parent pay child or spousal support, or that one parent be evicted from the home because of the unbearable circumstances in the home. So this would have been in the 70s, 80s, and 90s. And then along came the brand new family court rules, family law rules. And they introduced this new idea called a case conference. And the idea behind the case conference was we're not going to allow people, as a matter of course, as a first step in their divorce, to show up to court and argue. We're going to instead get rid of the word argue or argument, and we're going to change the language to conference or to confer or to settle. So, what once was a motion, which was a hearing resulting in a temporary order, was replaced with this concept called a conference, a case conference. And in fact, the rules even said you're not even allowed to have a motion before you have a case conference. And in fact, it went one step further. You're not even allowed to serve your notice of motion and your affidavit before you have a case conference. So not only were you not allowed to have a motion, you're not even allowed to serve your materials for a motion until you have a case conference. And this was going swimmingly well for many, many years, whereby the motions were gone, case conferences were conducted, and people met with a judge for the first court appearance for a case conference where the judge would try to navigate this couple towards either a temporary settlement or a final settlement. And they found that the results were astounding. People that would fight on a motion now were settling cases, or at least temporarily, on a case conference. So that was really successful. And then what happened? COVID came. And when COVID came, people said, wait a minute. I don't have time for this case conference business. I need a ruling. Where are the kids going to live when they can only live in one home? So then the question became, well, can you bring a motion before a case conference? And then it started whittling around that, and to the point where there were motions being heard before case conferences to determine where the kids were going to live. So we are now back to this post-COVID window where judges feel very strongly that you really should not be coming to court on a motion, because a motion pits one person against the other, asking a judge to make an order, whereas a case conference is where a judge says, look, I hear both sides, here's what I recommend. And the idea behind a case conference is a judge makes recommendations for settlement instead of a judge making rulings, which a judge would do on a motion.
Okay, thank you for breaking that down because that's much more clear. Okay, now let's get into what a case conference actually is. For someone who has never been to family court before, can you walk us through what a case conference actually is and what it's not? Because a lot of people come in expecting something very different from what actually happens.
So, by way of background, there are a number of hoops that any separating spouse must go through before they could even make it in front of a judge on a case conference. Hoop number one, and by the way, I'm about to describe hoops, whether somebody has a lawyer or not, because in Ontario, you're allowed to go through all of these hoops without a lawyer, or you can have a lawyer on a limited scope basis help you at certain stages and then exit and then use a limited scope lawyer on and off. But with that said, whether you have a lawyer or you don't, in order to get your case in the court system, you have to have either an application prepared,
Mhm.
issued in court, served on the other spouse. And if you're not the applicant with an application, you're likely the respondent filing an answer. So those documents are called pleadings. Stage one of every court case are pleadings. If you don't have pleadings, you don't have a court case. And if you don't have a court case, you can't get in front of a judge on a case conference. Assuming you've done the pleadings, which, by the way, easily can take a couple months because it takes time to prepare an application. And if your application involves children, you have to prepare other documents like a parenting affidavit, setting out the history of the children and if they have special needs and if there's been any history of domestic violence or criminal behavior. And if your application involves money, like support or property or homes, you have to fill out another document called a financial statement. That, by the way, is a very lengthy document. So the pleading stage could easily take a couple months. And then, assuming the pleadings are done, you can have a case conference. You got to book a case conference. And in this era, you can book it online through various government apps like Calendly or the JSO portal, Justice Services Ontario. And assuming you've got a case conference date, you need to then prepare a case conference brief. Each spouse prepares a CCB, a case conference brief. And the case conference brief is actually a formatted document. It actually has boxes you have to fill out. You've got to put in all of the basic information, everybody's name, date of birth, the children, what schools they go to, the ages of everybody, what the issues are that you want resolved, what the issues are that you've already resolved. And then it has a section where you could set out what you want the judge at the case conference to deal with. Sometimes you don't want the judge to deal with something that is not urgent. You might want the judge to deal with where are the kids going to live right now, or what school should they go to right now, or who's going to pay the mortgage right now. And so that's what goes into the CCB for each side. The judge reads the two case conference briefs and convenes a case conference. In some jurisdictions, it's live, meaning everybody drives down to the courthouse, parks their car, goes through the security checks, and then walks into the courtroom, sits down at the desk. Judge walks in and begins a case conference. And in some cases, it's done by Zoom, where just like this webinar, people dial in or log in to the Zoom link, and the case conference starts. And generally speaking, case conferences are private, meaning the world doesn't show up. But what ends up happening is you've got just the spouses and their lawyers. Sometimes people will try to bring a friend or a family member or even children. Judges don't really like that. And if one side says, I don't want anybody in the room or I don't want anybody on the screen, generally speaking, the judges will ask that person to exit because it's meant to be a private session. And so once the case conference begins, the judge generally says, I've read both briefs. I'm going to let the applicant speak first for a few minutes. Then I'm going to hear from the respondent. And then I, the judge, will give recommendations for settlement. And in some cases, people aren't ready to settle because they might need more information. Maybe they need a home appraisal. Maybe they need the report cards from school. Maybe they need a therapist's report on how the children are doing. So sometimes the judge isn't ready to make a recommendation, and the judge will make orders for more documents that need to be produced, and the judge might book another conference for another date. The general idea is the conferences are supposed to be valuable, like they're supposed to move cases in the direction of a collaborative resolution, even when people particularly are not collaborative. And then if you've had a case conference, that's when you are allowed to later have a motion. And if you don't have a case conference, you can't have a motion, like I said. But if you've had a case conference, now the door is open, the gate is open, you can have a motion.
And speaking of motions, Steve, there's a question in the chat. If there is an emergency, can someone ask for an emergency motion before a case conference?
Very good question. And so, as I said a few minutes ago, during COVID, people were deeming a lot as an emergency. And funny, language is interesting because what you might think is an emergency, somebody else might not. So you might think, well, husband pulled child out of daycare and on his days keeps child at home instead of sending child to daycare. And when mom goes to work, drops child off at daycare, and mom is not happy that dad pulled child out of daycare on his days, that's an emergency. Some people might say, well, he hasn't paid the mortgage and now he's left the mortgage payments on me only. That's an emergency. And the judges have, mainly through COVID, given more meaning to what is that word, emergency. And interestingly, there's even case law now to define what is or is not an emergency. And the judges have now said, you know what? We're not going to let everybody call something an emergency and just walk into court on a motion. And so somebody has to really convince the judge that their problem is an emergency. And it's gotten to the point where emergencies have shrunk in terms of what falls through the cracks. And so a child at an airport about to board a plane to go to a non-Hague Convention country, emergency. Non-payment of a mortgage, not emergency. Can't agree on daycare, not emergency. But some judges have been a little bit more concerned about making somebody wait 2, 3, 4 months for a case conference. So they would say, we're going to give you an urgent case conference. By the way, notice the language change. They've gone from the word emergency to urgent. I'm not so sure if there's much of a difference, but the judges have said, we're not going to use the word emergency, we're going to use the word urgent. So that's an urgent matter. We're going to have you at a case conference in the next few days. And the idea is let's move these people up on the rank so that they don't have to wait 2, 3, 4 months to get to a case conference. We'll let them have a urgent case conference. And if we can't resolve it at the urgent case conference, then we will give them the opportunity to have a motion. So if it really is an emergency and you could push it through and convince a judge it is an emergency, a judge might hear the matter either on a motion resulting in an emergency order, or a judge might say, no, but I will give you an urgent case conference and move you to the top of the line.
Okay. So you touched on this next question a little bit. Who's in the room and what's the judge's role? Are they there to decide anything that day specifically?
So first, let's talk about who's in the room. So
Yeah.
let's use the example of it being a live case conference. Everybody drove down to the courthouse. They went through security. They walked to the courthouse. If there's lawyers involved, they sometimes met outside or in the hallway. They walk into the courtroom. They literally wait for the door to the courtroom to be unlocked. Sometimes people have to wait outside. It's a little uncomfortable because if both spouses are sort of bumping into each other just outside of the courtroom door, and they go to the door and the door is not unlocked, so they can't go in. There's oftentimes conference rooms surrounding the courtroom door, so people will maybe plant themselves there until the door unlocks. Then they wait for the door to unlock. Then they go into the courtroom, and generally speaking, when the judge is looking out, the judge is looking against the direction that the participants are looking. So from
Okay.
the judge's perspective, the judge is looking left and right. And between left and right, there's a podium. Podium is generally speaking where the lawyer stands up and makes submissions to the judge. But when the lawyer looks out, oftentimes the judge is looking, sorry, to the left, that's the applicant, and to the right, that's the respondent. And sometimes people sit in the wrong side. And this is important because the judge wants to know who goes first. And the judge, generally speaking, asks the person who is to the judge's left, or if you're walking in the courtroom, it's to your right, to sit at that table. So if there's a lawyer and a client, they sit on the right table or to the judge's left side. And then the respondent spouse and their lawyer sits to the right side of the judge, or when you walk into the left side of the courtroom. Between the people
Hmm.
is the podium, and between the podium and the judge is another set of desks, which is where two people sit. One, the registrar, which is sort of like the judge's caddy. The registrar is the person that organizes the courtroom. They're the convener of the event. They're the ones that open court. They announce court is now in session. They're also the one that passes documents to the judge. The person, generally speaking, to the right of the registrar is a court reporter. In some case conferences, the judge will say, we don't need a court reporter. And in some case conferences, the judge will say, we do need a court reporter. I can tell you now, where there's lawyers involved, generally the judge says we don't need a court reporter. And if even one side is unrepresented, the judge asks the court reporter to remain and record. And the reason for that is because the judges never want to be blamed for having done something incorrectly. And generally speaking, the judges believe that if there are lawyers involved, that fear is no longer there. But sometimes they also have the court reporter there. For those that are wondering, you cannot order a transcript from a case conference. The court will not allow it. The idea behind it is that it is a confidential process. It is not allowed to be recorded. You cannot turn on your phone and record. And if you try to order the government sanctioned court reporter, transcript, you won't get it. It's blocked. And the idea behind it is nobody's allowed to use what goes on at a case conference outside of the case conference. And so at the case conference, the judge generally walks into the courtroom, and whether it's a woman or a man judge, they are announced. And then everybody stands up, bows to the judge. You wait for the judge to sit down. The registrar then says, "Court is now in session. You may be seated." Everybody sits down. And then nobody says a word. Judge speaks first. Judge says, "Good morning." You respond, "Good morning." You do not offer a good morning before the judge says good morning. Judges speak first. There's a lot of decorum. There's a lot of order. There's a lot of formality in the courtroom. Just because it's a conference doesn't mean it's any lesser than on a motion or a trial. And so the judge might say, "I've read the briefs," or "I've not read the briefs," or "so-and-so's brief was too long," or "so-and-so's brief was missing information," or "I couldn't find the brief." Whatever the judge says it, and then the judge will generally say, "I'll now hear from the applicant." So the judge will look to the judge's left or the right side of the courtroom and say, if I'm the lawyer for the applicant, they'll say, "Mr. Benmor, please introduce yourself and let us know what we can accomplish today." And I might say, "Your Honor, my name is Benmor, first initial S." I'll spell my name. And then I'll say, "I'm here as counsel for the applicant wife or applicant husband." And then I will say, "What we would like to accomplish today is," and I might say, "We would like your opinion on such and such," or "We would like you to make an order for financial disclosure," or "We would like you to make an order for the children to have their own counsel assigned to them by the Government of Ontario's office called the Office of the Children's Lawyer." Depending on what the circumstances are, what the issues are, I will then give the judge some context, and then I will say, generally speaking, "And that summarizes my submissions for today, Your Honor, and I'm here to answer any questions you may have." Judge might ask me some questions. Judge will then go to the respondent side and ask the respondent or the respondent's lawyer to make submissions. And then at some point, I might say, "May I respond?" Maybe I didn't like to hear what I heard. So I might say, "Your Honor, I have a response." Judge might allow me to make a response or not. And then the judge will roll into recommendations or potential procedural orders.
Thanks, Steve. That's really helpful. Now we're going to talk about what orders can judge make at a case conference. So even though it's not a trial, judges can make certain orders. What kinds of orders are actually on the table and which ones aren't?
That's a very good question, and it's actually a confusing one because there's a box in the CCB, in the case conference brief, that says, "What orders would you like the judge to make?" People read that and they think, "Well, I guess I'm going to ask for everything. I'm going to ask for sale of the home or spousal support, child support. I want decision-making authority over the kids." The judges do not make substantive orders. They will maybe make procedural orders. And this is hard. What's the difference? Nobody knows the difference typically from the word substantive to procedural. But the concept of a substantive order is something that affects someone's actual rights to children or to property. Whereas procedural orders are orders that are made to assist the process. So a procedural order could be an order that the children have a lawyer, or that there be an appraisal of the home, or that there be an expert assigned to assist in learning a little bit more about the case, or an order for financial disclosure, because how could anybody resolve anything substantively without having the disclosure? What I would like to do is I would like to share with our participants the rule. And on your screen, you will see the family law rules, and Rule 17 is the rule that we're talking about today. And if you scroll down to Rule 17, sub 4, it says right here, these are all of the reasons why you have a case conference. A, explore settlement. B, identify the issues. C, explore ways to resolve the issues in dispute. D, this is important, ensuring disclosure. To your question, Taya, what kind of orders does the judge make? disclosure of financial information, and so on and so forth. But let's go down a little bit further and look at the section called what kind of orders can a judge make? Well, there you go. Rule 17, sub 8 has a long list of orders. And as you can see, judge can order document disclosure, questioning, filing of summaries, setting timetables. Judges can make orders for expert opinion evidence. A judge can make orders for the next stage of a case. A judge can make an order, look at this, for a mandatory information program. Or look at this one, go to mediation. Or what about sending a couple to getting parenting courses? And by the way, this is a DCAO event, a program offered through any other available community service or resource. A judge can order a person or a couple to go and see a divorce coach. The judge has that power. And then, as you can see, there's a section here. If notice has been served, a judge can make certain orders. So, for example, a judge can order that somebody change a life insurance policy to list a beneficiary, or that assets be preserved, or that there not be any concealment or destruction of property. And so this is the list of all the orders a judge can make. And look at this one. On consent, refer them to an ADR process, which is like saying they can go to mediation. While we're here, I just want to point out that some jurisdictions don't have enough judges. So they added this extra rule at the bottom here, 17 sub 9, that says it doesn't have to be a judge. You guys could be sent to a non-judge case conference, which is called in Ontario a DRO, a dispute resolution officer.
Fascinating. There's so much in that. Um, so can a judge make an order without both parties agreeing? And if so, what happens then?
So, like I said, a judge can make orders that are procedural in nature, and
Right.
oftentimes the judge likes people to agree. So, for example, one side might say, I really need the other side's tax returns in order to calculate his or her income. And the judge might turn to the other side and go, that sounds reasonable. What do you think? And if the person says, no, I don't want them to see my tax returns, a judge has the power to make the order that they give the tax returns.
Hmm.
But when we get a little deeper on some issues, for example, one side might say, I really want the bank statements for the last 8 years. Now the judge might say, well, what do you think about that other side? And the other side might say, that's a little onerous. 8 years of bank statements. There's 8 years, 12 per year, 12 times 8. That's 96 statements. I don't even know if I have them. I don't know if the bank still has them. Bank might only keep them for 3 or 6 years. Judge might say, you know what? I'm not making that order. You're going to have to bring a motion for that. So the judges exercise discretion even in the sphere of procedural orders. And rarely, but sometimes, judges will make orders that are not on consent. So, for example, if someone comes to court and says, between the time that we split up and now, my ex-wife has been selling off all of her assets, her jewelry, liquidating her investment portfolio. And a person might say, I want an order stopping her dissipation of assets. A judge might very well make a temporary order saying you're not allowed to continue selling things off. That's just to preserve the status quo.
Right. Okay.
Now, there's a question in the chat. Um, the question is, after the case conference, can we proceed directly with filing a motion, or must we seek leave from the court beforehand?
So, very good question. For those that don't know what the word leave means, it doesn't mean what you think it means. It doesn't mean, hey, judge, can I leave the courtroom right now? The word leave is a fancy word for permission. So, when you ask a judge for leave, you're asking the judge for permission. Some people will ask the judge to write in the judge's endorsement. By the way, that's a new word, endorsement. The endorsement is the judge's writing of a court order that says what happened at the end of the case conference or at the end of a motion. So an endorsement is not saying, hey, I'm really into that restaurant or I'm really into that outfit. That's a street endorsement. In family court, an endorsement is a court order. And a judge might write in the endorsement, I grant the applicant leave to bring a motion, which is another way of saying permission. Now, do you need leave to bring a motion? Generally speaking, no. But every once in a while, people will ask for the judge to write in the endorsement the word the applicant or the respondent or both parties have leave to bring motions or leave to bring a motion for fill in the blank, child support, sale of the home, whatever. Why? Because sometimes people at the case conference will say, I want to bring a motion for this, that, the other thing, and eight other things. And then the judge will say, wait a minute. I'm not allowing you guys to bring all those motions. I'm only going to grant leave for each of you to bring one motion. And so that's where the word a judge can grant leave to bring a motion on X. And the practice directions have gotten narrower and narrower and narrower. And judges today in 2026 now are writing no more motions or only one motion. Because some cases, and now remember, out of 100 people that marry, around 50 split up. Out of those 50 that split up, about 10 of them go to court. Out of the 10 that go to court, about two or three of them are high conflict. And those high conflict cases, they are frequent flyers in the court system. And they come back to court over and over and over again to the point where judges are like, what is this, the fourth motion, the eighth motion, the 16th motion? So sometimes judges will say, no more motions. You're done. We're sending you off to trial. So the question of the questioner about do you need leave? You don't technically need leave, but some people will deliberately ask for leave so that it's clear that they have permission to do so. And sometimes judges will, without even people asking, will limit the leave to only one or two motions.
Okay, thank you for that, Steve. Okay, now let's dive into what should go into a case conference brief. For someone preparing their brief without a lawyer, what are the absolute must-haves and what does the court need to see?
So I'm going to also put up on the screen again the rule. And as you can see here, Rule 17, sub 13 says at the very top, each party shall, within the times required under Rule 13.1, serve and file the following documents. So for a case conference, it's Form 17A or B. And that is the requirement. And then underneath that, it says the time for filing under Rule 13.1 is so and so. And then you have to file another document called a confirmation, and that's in Form 17F and gives you the timeline for that. These are all documents that, generally speaking, are filed in advance of the case conference. And the reason for the confirmation is to say to the judge, this is in fact going ahead, and these are the issues that we want you, judge, to deal with. And the case conference is the document that says what it is that the case is all about. So now, what goes into a CCB, a case conference brief? Like I said earlier, a whole bunch of information about the family, like
Mhm.
who's in the family network, name of spouses or partners, name of children. Sometimes there are children from previous relationships. Sometimes there are children that are adult children. Sometimes there are children that are minor children that are involved in the case. So first, the judge wants to know who's in this scene. And so you got the list of everybody, their names, their dates of birth, what schools they go to if they are in school. And then it lists the issues. And then there's a box that says these are the issues that have already been resolved. Sometimes people have already resolved some issues. In other words, they may have gone to mediation, they might have solved a few things, but then there's a few things left over. Judges like to know what has been resolved already. That way
Mhm.
they can work on top of that, which is great. And then you list the topics for the case conference, and you also can attach to the CCB the documents that you want the judge to read. So there might be, for example, a home appraisal. There might be a therapy record. There might be a student record that indicates that a child is struggling in school. There might be a clinical investigation report from the Office of the Children's Lawyer making recommendations for the purposes of parenting. So you can attach certain documents to the CCB. And by the way, this is where things get really high tech. Judges have been forced to learn how to use technology, but I use the word forced because a lot of judges are somewhere between 45 and 75 years old, and they didn't grow up with all the tech that the Gen Zs did. And so, for example, when you file documents, the judges have come to like hyperlinks. So if they're reading your case conference brief and you want the judge to read an attachment, it's very smart to set it up in the body of the CCB so that the judge clicks the hyperlink and takes the judge directly there. That way, the judge doesn't have to go to another place to find it. And there are a list of documents that you're allowed to attach, and there are documents that you're not allowed to attach. Judges really don't want to read every text message between a couple for the last 3 years. Some people think, well, I want the judge to read everything. Well, the judge isn't going to read everything. In fact, the judges have even put limits on how long a brief can be. And if you exceed the limit, the judge will just stop reading. So you don't want to belabor the court or the judge with lengthy briefs. You want to be very concise. And the judges really appreciate it when these briefs are very tight. And the judges, for the most part, they want to help. And they can't help if you dump a dump truck on them. But they can help if you say, look, for today, we really just want an opinion and recommendations on should we keep the home or sell the home? Should the kids be in a shared parenting arrangement? Or should they be with one parent most of the time? Should the children change schools or stay in the existing school? Is this a case where child support should be paid or not? So the more narrow you are on a case conference, the more help you will get from a judge. And it starts from the brief and the material that is in the brief that you're sharing with a judge to read in advance.
Some really great tips. Thank you for that. So what would you say are the most common mistakes that self-represented people make in their brief? Like what's going to end up hurting them or slowing things down other than the volume?
Yeah, so I can tell you that, and this is really good news for the self-represented litigants, lawyers also make mistakes. So rule number one is know the rules. A lot of people think, well, I'll do whatever I want to do. No. Case conference briefs have rules. Got to read the rule. I showed you Rule 17, but there's other places for the rules. One other place for the rules is the practice direction. And if you were to Google the Ontario Family Court Practice Direction, it will set out for you more rules, such as that you have to make sure that the brief is double spaced, that you cannot use 8-point font. And some people will think, well, if I'm only allowed 8 pages or 12 pages or 10 pages, oh, I have a hack for that. I'll just go 6-point font. I'll move the margins to the far left and the far right, and I'll make what would otherwise be a 30-page brief under the page limits required. That's a surefire way to really upset the judge before the judge even gets into the courtroom and meets you. So read Rule 17, read the practice direction, and I'm going to go one step further. Most people have never been to a case conference. Read a couple of the endorsements. on canley.org for case conferences. There's a great case named Rosen and Rosen. It talked about case conferences and what you could expect from them. There's also, I'm going to put up on the screen, a great case that was written by a judge, and I'm going to show it to you right now. For those of you that are wondering, this document on your screen is found on my website under Library. And if you go under Library, there's a button called What Occurs at Case Conferences. And looky, looky, this is a judge's endorsement. Judge Price wrote in a 2021 case called Casson and Casson a really amazing description of how to do a case conference. In fact, he went up one step further. After a case conference, there's another event called a settlement conference. And then after that, there's a trial management conference. And the judge then writes in great detail what you do at these conferences. And I'm not going to read all of it to you, but it is all right there. And I would recommend that you read it. Let me just at least read one little piece that Judge Price wrote. The conferences in a family law proceeding are an important means of enabling the parties to achieve a just outcome at the least cost and with the least delay. The case conference plays an important role by ensuring that each of the parties has the information and documents they need in order to make or assess offers to settle. If a party lacks a document that is likely to affect his or her willingness to accept a settlement, the party's lawyer is unlikely to want to advise acceptance. And so that is an example of how to make a case conference successful, what to include in the brief, and how to prepare for it. And so I would strongly recommend that you read that article, or at least that case. And that case comes, by the way, from the third source of information that I mentioned, canley.org. And that way, when you think about the mistakes that can be avoided, first of all, know what the rules are. Second of all, know how to properly prepare, serve, and file a case conference brief. Last thing you want is for the judge to say, I got the respondent's brief, but I have no idea where the applicant's brief is. Well, talk about egg on your face if you're the applicant, because then the judge has got nothing on you. And let's just say the respondent's got a one leg up on you because the judge read one side and not the other. Well, that's not going to go very well. So know the rules, make sure the materials are before the judge, and be ready to engage with the judge in a wholesome discussion of what you think you can accomplish. Now, remember, these case conferences are roughly an hour, but divide that between two sides and the judge. Let's just allow the judge at least 1/3 of the time. So that's 20 minutes to the judge. Then you've got 40 minutes left. It's 20 minutes per each side. But what if in the 20 minutes that you're given, the judge has a few questions? That might eat into 5 to 10 minutes of your 20 minutes. So now you're down to 10 minutes. If you showed up expecting to speak for an hour and you're only speaking for 10 minutes, you're going to be very frustrated. So may I suggest that you prepare your talking points and maybe have talking points no different than a prime minister or a president prepares talking points for a debate on TV during an election campaign. You want to prepare your cards, your talking points. And so you can flip your card to when the judge talks about parenting, you've got your 5 bullets. When the judge talks about support, you've got your 5 bullets and you're good to go. Because remember, just like presidents and prime ministers with a camera pointing at them, when people show up in family court and their ex-husband or wife is sitting a few feet away and there's a bunch of lawyers and there's a registrar and a court reporter and you're being recorded and the judge is staring at you from high above, by the way, you're nervous. Whether you're a lawyer or a litigant, you're nervous. You're not going to remember your great preparation at home. You're going to freeze. You're going to be tongue-tied. Those talking points are really important. so that you don't forget what you wanted to say. Last thing you want is to leave that day going, oh my God, I forgot the most important piece.
Absolutely. So, a lot more great tips. Thank you for that. And just for everybody in attendance, Steve's website has a lot of information that's really well laid out. So, you may want to check that out.
Let me
That's
say
just a little
this,
aside.
Taya.
Yeah.
Um, in the last 5 years, I have met dozens of people that are going to case conferences either on their own or one side has a lawyer and the other side doesn't. And I am so proud to say that the people that don't have a lawyer who use a divorce coach generally do not make mistakes and are surprising themselves on how successful they were at a case conference because everything that I just told you in the last 55 minutes is exactly the kind of training, coaching, and prep that Ontario's amazing divorce coaches like you, Taya, like Leona Harvie, and Heather Tannenbaum, and Jennifer Donison. This is the sort of work that is the work of angels in the field of divorce because very few people can afford the thousands of dollars of paying lawyers to prepare them, to prepare their documents. And so we've got so many people that are showing up in court ill prepared. And for those people, thank God for the divorce coaches that have supported them to make their experience, let's just say, at least less bad and generally far more successful.
Thank you for that, Steve. We try. Our last section of questions today dives deeper into what happens after a case conference. So, if you reach some agreement, how is that recorded and made official?
So at the end of the case conference, the judge will generally read out what she or he wrote in the endorsement. And the judge might write in the endorsement, today, case conference held. Wife was here with lawyer such and such. Husband was here with lawyer such and such. We discussed the issues of such and such. And I've granted leave for each side to bring a motion for parenting. And then after the case conference, generally the parties or the counsel and the parties will speak offline in emails, phone calls. They might go to mediation. They might try to resolve some issues. And if not, there will be a motion. Now, in some of the more high conflict cases, one or both lawyers will ask the judge to actually write in the endorsement the date of the motion and a timetable for the exchange of motion material. Nobody wants to get late served with motion material so that they don't have enough time to properly respond. So some of these endorsements will have details with respect to the timetable for all of the material and who is to go first and who's to go second and what the issues are and so on and so forth. Sometimes the judges will even grant you permission to go longer in your affidavit material than what the rules and the practice direction provide. So that's in the endorsement. So that way it's clear what the next step is. And the judges have now learned that an endorsement is sort of like a medical chart. So when you go to the doctor and you haven't seen the doctor in 3 months or in 3 years, oftentimes the doctor will pull out your chart and will read, what happened last time you were here? What did you complain about? What did the doctor recommend? What medication were you on or prescribed? Similarly, the judges treat the endorsements as a similar sort of format so that the next judge who touches the chart can look at the last endorsement and go, ah, I see what happened. Now, this is important. You got to treat these case conferences very seriously. Why? Because some people think, well, if it doesn't go well, I'll just ask the other judge for whatever it is that I want that I didn't get on the first round. Uh-uh. The judges will sometimes write things in the endorsement that is a little bit of code, maybe even cryptic, so that the next judge reading it gets the hint that something is askew. In other words, a judge might write in an endorsement, I made strong recommendations for parenting, and it is my hope that there is not going to be a parenting motion. Well, the judge didn't write anything about each person or about what the issues were, but that is code for this case should not have gone to a motion. So if somebody brings a motion in the future, the next judge is going to look at that and go, why is there a motion here? And if the judge smells that somebody is being unreasonable, well, that connects with an endorsement from a week or a month or a year ago where a judge wrote, I don't think this is a need for a motion. So be very careful on these case conferences. You do not want the judge to write something that might negatively influence the next judge's view. So conduct yourself with the utmost of integrity, be extremely respectful, and if the judge says something that you do not agree with, you do not have to debate the judge. You could simply say, thank you for your comments, Your Honor. I will take that under advisement. Even though what you're really thinking is, I completely disagree with what you just said. You just don't say that out loud.
Okay. Thank you for that. That's so interesting. Um, so my next question, and it's our last question, we'll get to whatever's in the chat in a moment. So if they don't reach an agreement, what happens next? And what's the most important thing a self-rep should do immediately after leaving the conference?
Well, immediately after, while it's fresh in your mind, even before you leave the building, go into a conference room, pull out your smartphone, turn on the recorder, and record as much as you could remember of what the other side said, what you said, and what the judge said. It's not going to be in the endorsement, and you were not allowed to record it in
Right.
the courtroom. Now, why is all that important? Because what the judge said, there's a pretty good chance the next judge after that, the judge after that will say that too. And you won't remember that an hour, a week, a year later.
Right.
So record it. Number two, if the judge made recommendations to do something, well, if you record it, you'll remember to do it or to not do something. Now, if you record what the other side argued, that is gold because the other side is going to argue those points later on another conference or another motion or a trial. Well, guess what? You just got a sneak preview of what their arguments are. Now, if you've recorded it, the next go around, you will be able to preempt or to overcome those arguments in your next round of material. Now, it may all be in their case conference brief, maybe, maybe not. But if the judge heard them argue something and you recorded that, and the judge responded in a negative light or in a positive light to what the other side argued, and you recorded that, now you've got the gold to move in the direction of settlement or an offer or a motion or a trial. And you have a number of options now after this case conference. You can go to a motion, you could invite mediation, you can deliver an offer, you could serve a request for information for more financial disclosure. If a judge ordered questioning, which is an out-of-court deposition process, then you can arrange that. So a lot will happen at and after the case conference. And remember what I read earlier about what Judge Price wrote in Casson and Casson, which is the purpose of the case conference is really to end the case, not to springboard the case. And so sometimes the case is closer to the end, but not yet there. And
Right.
that is going to be determined by the case conference. So I say, before you leave the topic, before you leave the building, or if it's on Zoom, before you go to the next activity in your life, make notes or record what happened, who said what, so that you can act on that. And for the benefit of the divorce coaches on this screen, those notes are so valuable for the divorce coach to assist the person in interpreting what's next for them in this journey.
Absolutely, Steve. So thank you for that. That is such an amazing amount of information, some really helpful tips that you've given everyone today. So now that closes our portion of the questions and answers that we were going to go through. Leona, do we have any questions in the chat?
Yeah, we have one question and we have one point. So Pratik pointed out that we have two practice directions, provincial practice directions and regional practice directions. So he had posted that after we spoke about that previously. So thank you for that comment. And in terms of a question, it seems more personal to a case, but you may be able to speak to this, Steve. But the question is, even after a first case conference and an order for full financial disclosure, when the father has not provided his tax returns or disclosed his bank accounts after, I guess, separation in this process, can the mother raising the children request for a delay in the sale of the matrimonial home until full financial, I guess, disclosure is received? And
The
the
answer
father
is
is a significantly higher income earner.
so questions are always asked, can I ask for something? There's no
Mhm.
law that says you cannot ask. The bigger question is, will you get it? And the answer is, wait for it. It depends. So, for example, at a case conference, the judge is not going to order the sale of a home. I've never heard that ever happen. But a judge could grant a motion date for there to be a motion to determine whether the home should be sold. And the person who is resisting the motion for the sale of the home may very well argue that the home cannot and should not be sold unless and until there's been full financial disclosure. And by the way, it's a very good argument. And by the way, on a motion for the sale of a matrimonial home, there needs to be financial disclosure made so the judge could consider whether the sale of the home is appropriate or not. So, again, it's a case specific question. And the safest way for me to answer it is it depends. But let me say this just in the last month, I've read two cases where a judge denied the sale of the home in various circumstances, which I say that with alert because it historically has been the case that if it's a jointly owned matrimonial home, judges, as a matter of course, order the sale. But recently, we've seen some cases where the judges have said, you know what? It's not appropriate. I'm not ordering the sale. And so this is a situation again where the conversation between the divorce coach and the self-represented litigant, or quite frankly, even the litigant who has a lawyer, has a wholesome conversation with their lawyer and their divorce coach to sort out how do we deal with this situation? Either I want the home sold, I don't want the home sold, maybe the home can be sold, but on the condition of financial disclosure or on the condition that a certain sum of money from the sale of the home will be paid to the person who generally did not want the home sold, but will agree to the sale, but on certain conditions. So this is a really sweet spot for negotiating a soft landing.
That's interesting. Wow. Okay. Um, do we have any other questions, Leona? Or is that it for
That's
today?
it for the chat,
Okay.
unless anybody else wants to add one.
We are at time. So, like I said earlier, we will be emailing everybody with the recording from today. Um, and I guess that's it for today, unless we've got any last second question. Okay. Well, thank you so much for joining us today, everybody. We hope you have a fantastic day.
And
And
I would suggest for those people that are at all interested in this sort of education, if you were to visit the Divorce Coaches Association of Ontario website, you will find, first of all, loads of valuable information about the utility, the merit, the value of divorce coaching and divorce coaches. Secondly, you'll have the opportunity to see our many members who offer services in a variety of fields for people that are going through separation and divorce and having parenting issues. But also, you will find our next set of events for those people that are navigating a separation or divorce on their own. And even today, we've had lawyers and law students join us today. And these programs, I hope, are valuable to everybody. People that are lawyers, divorce coaches, and of course, our dear self-represented litigants who have been forced to navigate this on their own. So please take advantage of it. We are here to help you, and we want to see you all succeed. So thank you.
Absolutely. And just a point on that, the next one is June 10th, and it's the ABCs of financial disclosure in family court. When we send out the email with the recording, we'll also include a link to sign up for the next one, okay? So
Thank you, everybody. Be
thank you,
well.
Thank
Take
everyone.
you.
care.